She was the only girl. She had 5 brothers. She became a nurse. She joined the Navy. She eventually made a naval captain. Marion Deans also went through a very difficult and bitter divorce, a very difficult and bitter child custody battle, and eventually was trying to raise and provide for 3 children while working for the military. She would often have to leave her children with family in Tampa. Nicole Nachtman grew up an Army brat, basically. She was having to transfer all the time. Whenever Marion Deans would get deployed, Nicole Nachtman needed to go somewhere. So she would bring her to Tampa so she could be with family. What else is she going to do? But yet she's going to be blamed because Nicole Nachtman had to go to so many schools. We never said, and I said it in my opening, that Nicole Nachtman did not have an easy life. I said that. We've never tried to portray a perfect picture. We never have. I've never tried to tell you, and I never argued to you up here in opening, that Miss Deans was a perfect parent. She was not. She made mistakes. But those mistakes, ladies and gentlemen, do not give Nicole Nachtman the right to kill her. They do not. She might not have been super loving. Clearly she wasn't. You've heard testimony about that. But she did the best she could, according to Dr. Lazaro, for Nicole Nachtman, the best way she knew how to parent. Ladies and gentlemen, children grow up in foster care and don't have parents doting love on them, and they don't go out and kill people. Just because you've had a hard life does not give you the right to kill people when you want to. It just does not. And the only reason we're even discussing much of this stuff with Marion Deans and the raising of Nicole Nachtman is because they put forth a defense of battered child syndrome. Nicole Nachtman was not a child when this occurred. I want to remind you all of that. She was 21 years old. But they put forth this defense of battered child syndrome because it goes to self-defense. And I want to remind you also, ladies and gentlemen, this goes only as to the count involving Marion Deans. I believe that's count 2 of the indictment. It only applies to her. Self-defense does not apply whatsoever to Robert Deans. It just does not. So this is put on to a self-defense instruction. Because in a self-defense instruction, you have to have a reasonable belief of bodily harm in order to defend yourself, basically. I mean, I'm kind of paraphrasing it, but that's pretty much how it goes. And you'll see the instruction, and the judge will read you the law on it. But with battered child syndrome, when you put that onto the self-defense instruction, it says you have to look at it from the mind of a battered child syndrome. Was it reasonable for a person under her circumstances to believe she was in fear of death or great bodily harm? And I submit to you it was not reasonable for her to believe that, for many reasons. Now, Dr. Lazaro has already told you she did not feel that what Nicole suffered, while she never excused it or said it was good, did not rise to the level of battered child syndrome. We talked about the physical abuse and how it was limited. All 3 doctors said it was limited. They came up with 3 instances in her entire 21 years of actual physical abuse that they would categorize as physical abuse. 3 in 21 years. Now, that's not to excuse that. That's not to say that Ms. Deans was ever right to do anything like that to her child. We are not excusing that. Okay, and I don't want you to misinterpret what I'm telling you as to tell you that Ms. Deans was correct in kicking her daughter for not answering a question or pushing her head down onto a table. None of that was correct. The question is, does it rise to the level of battered child syndrome? Dr. Lazaro explained to you, and let me remind you, even Dr. Heidi said, if it was just this physical abuse, I would say no, this doesn't go to that level. Dr. Lazaro explained to you how it's a process where they get battered, then there's an apology, then it comes back up again and get battered again, and it's a cycle. What have we heard about here? One when she was 3 years old, or in 3rd grade, I can't remember which one it was, and then one when she was in 10th grade, and one when she was in 11th grade. Those were the 3 instances we're talking about. So, Dr. Heidi knows that that's not going to be enough for battered child syndrome. So she looks at other avenues and other areas where Miss Nachtman might have been abused. So she turns to the verbal and the psychological. And yes, there is some evidence of that as well. There is some evidence, you heard from Joseph Carey, that the mom could be kind of abrasive and say mean things to them from time to time. He never said he ever heard her say one thing to Nicole. He said she would say things like that. That's who she is. But he could not say a specific instance that he remembers her ever saying anything like that to Nicole. Because I want to remind you, ladies and gentlemen, that majority, just the 3 instances of violence and all of the psychological and verbal abuse you heard from, especially the verbal abuse, all came from the self-reporting of Nicole Nachtman. All of it. A woman we know who has no trouble lying to get out of trouble. No trouble at all. She'll fake her grades. She'll buy a storage unit for a bike. She'll tell detectives that she's been in Florida State for more than 2 days. So we're to rely on this skank and all these other words that were uttered to her at specific times in her life as true. You all can weigh that for what it is. But does that, all of that combined, still arise to the level of a battered child? You have other evidence you can look at aside from the words of Nicole Nachtman, and that is those emails. I urge you to look through those emails. And I'm sorry, I call them emails. I do this all the time. They're texts. I get them confused in my head. Okay. But I would ask you to look through those. And I think what you will see is that it's a normal back and forth relationship between a mother and daughter. Now, it wasn't loving, but we've already established that Miriam Deans was not a loving type. Not one to show affection openly like that. But if you read through them, you'll see silly things like, oh, so-and-so's bringing a present for you, and da-da-da-da. And then she'll say, are you mad at me? And Miriam Deans replies, I could never be mad at you, Nicole. You'll find that text in there. I could never be mad at you, Nicole. That is hard evidence that you can look at and see for yourself. You know, and I want you all to remember this too. You heard from Dr. Lazaro that her mom was trying to do the best for Nicole. And some of these things, I think some of us would agree, is probably inappropriate. Certainly, some of these fat-shaming comments that we hear. But if you look at the text, they're not fat-shaming. It's a nurse saying, this is what your weight should be. Remember, don't eat after 7. Things that a mom might say to help a child or a young adult to keep their weight down. Remember, she's a nurse. She never says, you're getting fat, Nicole. Not a single text in there that says anything like that. The liposuction, Nicole was not a child then. I want you all to remember that. She was over 18 when she got the liposuction. And she had a choice in that. No doctor would ever perform a procedure without...
Objection to facts not in evidence.
I'll sustain, move on.
All right. you are hearing from the defense the worst moments of the relationship between Miriam Deans and Nicole Nachtman. Miriam Deans isn't alive right now to tell you or explain to you or give you her side of what happened. In some of these moments, in frustration, when she might have hurt Nicole, I'm sure if she were alive today, she may regret. But this is a 21-year picture, and you're only seeing these brief moments of this time. But none of it arises to the level of battered child. The defense wants to downplay the things her mom got her. Try to say that the state is saying it's a perfect life. I'm not saying it's perfect, but her mom did provide for her in a great way. She worked hard to provide for her. She gave her things she needed. She needed a car to get around. You got a car, Nicole. She got Florida Prepaid. Florida Prepaid takes time to pay for. She got her computers when she needed computers. She tried to put her in schools that she thought would be good for her. Family may have objected, but remember, it's not the family's choice. And you are not here to judge her choice of where she put Nicole in school. You're here to judge whether that abuse arose to the level of battered child syndrome, and then whether, with that, it was reasonable for Nicole Nachtman to believe that she was in fear of imminent death or great bodily harm. Don't forget, she could have left. If she was so scared she had her room, she could have been in Tallahassee, miles away from her mom. She chose to stay. Why? Because by that point in time, Nicole Nachtman had already made the decision in her head that she was done with her mom. She wanted her out of her life, and this was the way she was going to do it. Now, I know she'd already killed Bob, but that's only one body. She could have moved on and saved. But no, she because her plan was to kill her mom, she had to follow it through to the end. Even when Miriam Deans does something that could easily be perceived as something really good, she shows up at her child's school to pick her up. Nicole thinks Bob's coming. And she even plays along. Oh yeah, Bob's on his way up there. He'll come get you. And then she comes out. Now, how do we know, ladies and gentlemen, that's not just a fun thing that she wanted to do? Surprise her daughter. Spend some time driving back down to Tampa with her daughter. How do we know? We don't. But what does Dr. Ewing say? Oh, she's gaslighting her. If that doesn't show you bias on the part of that doctor, I don't know what does. He's making a judgment about Miriam Dean's decisions without having any idea. That is bias. You have to look at his opinion very carefully. And I confronted him. I said, do you have any evidence or any reason to believe she was just coming to surprise her? Well, no. Well, then why did you tell this jury a little while ago that she was gaslighting her? They complained that she never went up to Tallahassee to see her. Well, there she did. And instead of being like, oh, she did a good thing, oh, she was gaslighting her. Miriam can't win for losing. But I remind you, this case is not about Nicole Nachtman versus Miriam Deans. It's about State of Florida versus Nicole Nachtman. Please keep that in mind. So when you look at self-defense, you need to look and see what were the circumstances. What happened at that moment? All three doctors testified that Nicole Nachtman never says that her mom was coming at her in an aggressive or angry fashion. She never says that. Her mom was surprised. The trap had worked perfectly. Perfect. Mom's like, Nicole, what the are you doing here? It had worked perfect. If her mom had pulled up and seen the car, her mom might have been coming in like a little more aggressively, like, what's going on? No, she didn't want that. She wanted to catch her mom right off guard, and she did. And there's no evidence whatsoever that the mother did anything to give her a reason to believe she was in fear of death or great bodily harm. Nothing. She didn't want the repercussions of her mom yelling at her, mad at her because she didn't do what she was supposed to do with the housing. This had nothing to do with her fear of death or great bodily harm. And there is no evidence, ladies and gentlemen, not a scintilla, not even a single piece of evidence to show any sort of aggressive action on the part of Miriam Deans. Nothing. Self-defense doesn't apply here. Not even at all. It's not even a close call. So much talk. Oh, let me also talk about this when it comes to this self-defense. Miss Hersey here talked a few minutes ago about the bullets in the wound she took. And yes, there was one within 2 feet, the muzzle right here, barrel about 2 feet from the body. And that was the one that was directly to the torso. The one that goes straight front to back. I suggest to you, ladies and gentlemen, that was clearly the first shot. It's also the shot that the medical examiner said had the most blood coming out of the areas where it was shot. So clearly it was the first shot. And what does she say happens after that? Her mom screams. What do the neighbors say they heard? Scream. It was a weird scream, like an agony scream. So that's the first shot. In all likelihood, what is Miriam Deans going to do? She's going to turn from the threat. And you heard Wesley Rowe and Elizabeth Ray both say they heard a bang and then bang, bang. 2 quick succession bangs. So the first one goes front to back and it's right here in her front and it's pretty close range. The next one comes in her side and goes from her left side across her body. And then there's one right in her head that comes from the back of her head through her ear and comes out towards the front of her head. So her head was turned. She was trying to get away. She was trying to run for her life. But Nicole Nachtman was not going to let her get away. Not now. Not anymore. She was done with her mom. And we can surmise that this is the last wound because it had the least amount of blood in the areas where it traveled. And after this wound, the doctor said most likely she would collapse, which she did. Her arms were by her side. She clearly didn't even try and break or fall. And you see the bruising and the blunt impact, and he said there was very little on the contusion to show that there was much blood pressure left, if any. So, ladies and gentlemen, the last thing she saw in her life was that woman with a gun to her. So this is not self-defense. But what about Bob? You know, I would say easily 3/4, if not more, of this case has all been discussion about Miriam Deans and Miriam Deans and Miriam Deans. What about Robert Deans? Talk about an innocent, complete innocent man. He had nothing. He did nothing wrong. His only thing he did wrong was to stand in the way of her mom. No evidence he ever abused her, no evidence he ever yelled at her, no evidence he ever did anything to Nicole Nachtman. He put her on his health insurance. We know that because, according to the Air Academy records, he's on his health insurance. He's the stepfather. How close he was to her? I don't know. There's no telling. David Lear, the cousin who gave her the money, says they all seem fine. I would be over and visit 2 or 3 times a week. Now, Eric and George never talked about going to visit the house. You never heard any testimony from them about going to visit the house and see what the house was like. But David did. David got to know Robert Deans. He would help him with projects around the house. Said he was a very nice guy. He's the one who identified him on the picture, in the Publix video. So Robert was very nice. So what did he do to Nicole? Nothing. He did nothing to her. But stand in the way of her ultimate goal. That's all it was. She knew her mom was gone. She was in the house with Robert Deans. And according to the testimony from the doctors, she was contemplating suicide. Am I going to kill myself? She had taken the gun out of the bedroom. And I urge you to look at those pictures too. If you look at the empty gun case, you'll look and see that there's a novel inside it, a Stephen King novel. Why do you think that's there? Because she didn't want them to know that something might have been missing in case they moved the case. So it still had weight to it. That's smart. That's not someone who's undergoing a psychotic episode. That's not someone who's suffering from some hallucination and delusion. They don't know what they're doing. She knew what she was doing. She takes that gun and thinks, am I going to kill myself? What does that tell you? Nicole Nachtman knows what a gun can do. She knows it kills. I mean, common sense tells you she does. She's a Florida State University student with average to above average intelligence. She knows what it is. So she decides for herself, no, I want to live. She walks out, comes up from behind Robert Deans and shoots him in the back of the head, killing him. Now let's talk a little bit about insanity, because that's the defense they are attempting to prove to you. And remember, it is their burden to prove to you by clear and convincing evidence. She is presumed sane. As she sits there right now, you're to presume her that she's sane, just like all of us. It's their duty and their job to convince you with clear and convincing evidence that she was not, that she was insane at the time of the offense. So let's start looking into that evidence. Mental infirmity. You'll see in a second, I'll put it up. You all have seen it a bunch of times already, so I know you're going to be very familiar with this when he gets back there with you. But it's important that you all understand it, because it can become somewhat confusing. And that first line that they've read, you've read that a bunch of times, but a person is considered to be insane when, number one, she had a mental infirmity, disease, or defect. We agree. We're not contesting that. You heard so much evidence about, is it schizophrenia? Is it schizotype of personality disorder? It doesn't matter. It doesn't matter. It could be schizophrenia. Dr. Lazaro was going to lose no money if she said, yeah, it's schizophrenic, but she's not insane because of blah, 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 blah. She could have diagnosed her with whatever she wanted. She diagnosed her with a mental disease or defect. So it doesn't matter. She wouldn't have lost any money anyway. Dr. Lazaro was bringing to you what she believed the evidence in her diagnosis to be. Pure and simple. But, in her opinion, it's not as severe as the defense would have you believe. She does not believe that Nicole Nachtman was suffering with delusions. She indicated that the delusion that they keep referring to is that her mom was going to kill her. She has made that up since as a justification for her actions. Nicole Nachtman does not want to think she's a bad person. So she is now justifying it by saying, well, I thought my mom was going to kill me. She says to the doctor, in her statement, she says, you know, if she wasn't going to kill me before, once I kill Bob, then I know she's going to kill me. So that's not a delusion. Dr. Lazaro explained that to you. It's not a fixed, firm belief that will not change. Clearly it was changing, it was fluctuating. Because she wasn't certain she would kill her, but then once she killed Bob, oh, now she's going to kill me. Dr. Lazaro explained to you that while she suffered some schizophrenic symptoms and she was on the spectrum, it was not as severe. And certainly not to the point of being psychotic. And she told you some of the things that no psychotic person, no person under a psychosis who has a belief in undergoing a psychotic episode could ever do. Person going to go into a psychotic episode does not have executive function, as she described, does not have the ability to think things through and do things. So what is she doing? What is there evidence that she did not have any psychosis at the time? She was actively speaking with her family members. She saw David after she had killed her stepfather and while she was still planning to kill her mother. David said she seemed normal, had a normal conversation with her. She responded back to him in a normal fashion. She wanted the money. He gave her the money. When am I going to see you again? And she gave him a big hug because she wasn't sure when she'd see him again. Because by that point, she had already killed Robert Dean, so she knew she was going to go away. No indication from him that she was acting out of sorts in any manner from her normal manner. He testified to that. She called her grandmother and told her grandmother goodbye. Said she was sorry she didn't get a chance to see her before she leaves. She handled that entire thing with FSU. I mean, she just killed her stepfather, and she's awaiting her mom. And meanwhile, okay, let me deal with this FSU thing. I gotta get now that I got my housing, I can get out of here. I'll go up there to FSU, and I'll make it seem like I've been there the whole time. And she goes through all the things she needed to do to get that housing done. Paid the money, got the forms in, did everything she needed to do. That is a person who's functioning with a clean mind, knows what she's doing, and knows how to do what she's doing. Everyone wants to make it out, or I'm sorry, not everyone, the defense wants to make it out that poor Nicole Nachtman couldn't take care of herself, couldn't do anything. She moved herself up to school every time. That's a pretty big deal. She did it all by herself. She drives herself up there, she moves herself in. That's pretty big. She went to London by herself. She couldn't clean. She couldn't take care of herself. She couldn't wash her clothes or take. Well, you heard from the first roommate, the first woman. She testified actually during our case. We let her come in and have her testimony via Skype. And she could do it, and sometimes she would. I would yell at her, and she'd clean up for a little while, but then it would start to go back again. She was just lazy. Just wasn't in her mindset to clean or be clean. But when there's blood everywhere, she can clean that up pretty good. When there's blood on clothes and on sponges and stuff, well, let's clean that up pretty good. She can certainly clean that up. Nicole Nachtman knew how to clean. She's not this meek little girl who doesn't know how to do anything. That's not Nicole Nachtman. She was an average to above average intelligent 21-year-old woman. Nicole planned keeping the car out of the mother's view and parked it away from the house. That is very devious. It's devious to believe that you're setting this trap for her to begin with. But then where she parks, I mean, I urge you all to go back and look at this. She parks in an area almost 2 miles away, an area familiar to her because obviously that's where her brother lives. Her cousin David lives. But an area that's across Ehrlich Road in another subdivision so that when they hear the shots and the police start coming in like this, she won't be seen in her car leaving the area. She's on foot. Who knows where? She's hiding in bushes, running around trying to make sure she's not seen, and can make it all the way up here and then leave, whoop, right out of here, with her car never even being spotted around the area. That's smart. That's not someone who's insane or doesn't know what they're doing. Certainly not someone who's psychotic at the time. She went up to school, told her roommate to lie for her and say she was there if anyone asks. After the murder, she met with the police, and there's no evidence of any psychosis at all in the interview, and you all saw that interview. She's oriented to time and place. She can speak with him pretty clearly. She understands his questions. In fact, he doesn't even get a chance to read Miranda. She immediately knows where he's going with that and says, I've been told by my family I should get a lawyer. Is that okay? He's like, yeah, okay. He hadn't even started to tell her Miranda rights. She knew it. And then she went right back to the Ice Princess story. Now everyone keeps, I'm sorry, everyone. The defense keeps bringing up, oh, look at her. She's talking about the Ice Princess. She just killed her mom and stepmom, or stepdad. She's talking about the Ice Princess. Well, what else is she going to talk about? Someone who's trying to cover her tracks, someone who doesn't want the police to know. She's going to sit there and say, I murdered them. You got me. It was terrible. No. So she's going to talk about things that interest her. If she was into, football, she'd be talking about football. You heard from Detective Messer. It's very common when we're waiting around with a defendant who's invoked their rights that we just sit and we talk about other things. Whatever is interesting them. And to her, she's interested in that stuff. She gets on her Tumblr and writes stories. She loves the Ice Princess story, and she's changed it. And she puts her own characters in it. That's her hobby. That's her interest. That's the things she likes to do. The Elsa costume in the Elsa book. Do we know why she got the book? Maybe she got the book because she wanted some pictures of Elsa while she's trying to draw or put together her costume. I don't know. Doesn't really matter. Lots of people cosplay, which is called where you dress in costume of different characters. Teenage Mutant Ninja, you heard Dr. Lazaro talk about Teenage Mutant Ninja Turtles. There's no evidence of any psychosis in those phone calls that you just heard, is there? She understands what they're asking her. She's responding back. No evidence of any psychosis. She changed the Yahoo account when she was there. She learned she got on to change the password. That's someone who's functioning very well up here, not someone who's manic and psychotic and doesn't know what's going on and what they're doing. All of those actions show she was not psychotic. Now, in some respects, ladies and gentlemen, most people who kill generally have some mental issues. Most people who don't kill, so it's common for people who kill to have mental issues. And I want to point you to a thing here that I think is important, because we are admitting she does have a mental illness. We're not contesting that. We understand that. It says, although insanity is a defense, mental or psychiatric conditions not constituting insanity are not defenses to any crime in this case. That's important, ladies and gentlemen, because if you believe she knew what she was doing, she knew the consequences, and she knew it was wrong, then if she could be full-blown schizophrenic, whatever you want to call it, it doesn't matter. She's still guilty. She's not insane. Just because you have a mental disease or defect does not make you insane. Please remember that when you go back there. Because this second half of this is what's important. This is what distinguishes it. Because lots of people have mental conditions, and just because you have a mental condition doesn't mean you have a right to kill. We've talked about the schizophrenic who's working as a lawyer. There are people with mental diseases and defects all around this country who are functioning, working properly, and not killing people because they know it's wrong. And so did she. She admitted it was wrong. She admitted to Dr. Lazaro. Dr. Lazaro asked her, did you know? Or I think she said it this way, you knew killing your mom and stepdad was wrong, didn't you? And she said, yeah, I did. She admits it's wrong. In fact, Dr. Heidi said, yeah, it's wrong. She knew it was wrong. I don't contest that. She knew it was wrong. Who wouldn't admit it? Oh, back to Dr. Ewan, the one with, I told you, a bias. Because listen to what he said. He wouldn't make an opinion about it. He says there's evidence to suggest she didn't know, or she knew it was wrong. There's evidence to suggest that. Ladies and gentlemen, there's not evidence to suggest that. There's evidence to scream that. There is so much evidence that she knew it was wrong. She was looking for help to cover up the murders, for dangerous areas in Tampa, people in low places, so she could get a fake ID, so she could maybe get away, because she knew she was going to be wanted. She lied to her family about when she was leaving. She talked to her mother while Bob Dean's body was right there in that house, and her mother was on her way saying, "Oh yeah, Mom, I'm up here, yeah, my roommates, I just met my roommates." She was covering up, she's lying, she moved her car a distance away, she cleaned the crime scene, she moved the body to the back room. She drove up to school. She talked about how she knew the police were coming. When she shot Bob Dean, she was scared because it was loud, and she was sure the police were going to come. Right after she shot him, she said, "I thought, oh no, the police are going to come." Is that someone who knows it's wrong? Is that someone who knows what they're doing and knows the consequence of what they're doing? She lied to her uncle. If she'd done nothing wrong, she'd say, "Well, yeah, Uncle, I killed him. Mom was going to kill me, so I had to kill her. And Bob was, he was kind of there, so I had to kill him too." If she thought she'd done nothing wrong, she would have talked about it, but she didn't. She said, "Oh, no, I didn't have anything to do with that. Not me. I've been up here. I've been up here." What evidence is there to show that she knew what she was doing? Because we've already discussed the wrongness. And by the way, she also got rid of the weapon. Someone who's not guilty or doesn't believe they've done anything wrong won't dispose of the weapon.
Judge, I'm going to object at that point.
Let's move on.
So let's go back to, we've already established wrongness. And there are two prongs, or two ways you could go. And Ms. Hersey Fulgara told you, you can ignore that second one. Well, no, because if you find that she knew what she was doing, and she knew the consequences, then you have to find out whether or not she believed it was wrong. So yes, the state is asking you to look at all of it, not just to these two, the whole thing. So, going back to the first one, did she know what she was doing and its consequences? Now,
Judge, I'm going to object. That's a misstatement of the instruction.
okay, the statement is she did not know what she was doing. Okay, so did she know what she was doing, or did she know the consequences of what she was doing? Now, Dr. Heidi and I had a little argument about the legal definition of insanity. Because you heard Dr. Heidi basically changed her opinion. And she's going to split hairs with me, but I'm going to tell you, ladies and gentlemen, she knew what I was asking her back in that January hearing. At that time, insanity was not an issue in this case. So when I asked her on that January hearing those two questions, because I didn't really think it was an issue, but when I asked her those two questions, her response to me was, I said, did she know what she was doing and it was wrong? Oh yes, she did. Did she meet the McNaughton standard of insanity? No, she did not. Basically she was saying she was sane. But then she comes in before you and testifies and has changed that opinion now. But she wants to split hairs with me and say there's some other McNaughton standard that I don't know exists. that doesn't include the term consequence. So I had to point her to a Supreme Court of Florida. Now this is a criminology professor at USF. She knows the law. So I had to point her to it. I said, it says consequence in here under the McNaughton standard in Florida. She goes, oh, I didn't know that's what you were referring to. Come on, ladies and gentlemen. So Dr. Heidi was completely wrong. And if you listen to my cross, I did get her to basically agree that she knew what she was doing when she was shooting a gun. The indictment reads that she killed Robert Deans by shooting him. So what is the action of doing that we're here to determine? Did she know what she was doing? The doing in the indictment is the shooting him. What is the consequence of shooting him? He was killed. It's that simple. The defense wants to extend consequences into penalties he might receive in the future, or she might receive in the future. That's not what this says. Use your common sense.
I asked the court to instruct that it's the law as you will read it. Consequences.
I'm
not
arguing,
defined.
Judge.
It's argument, ladies and gentlemen. I will remind you, though, that what the attorneys say is not evidence or the law. I will instruct you on the law. I will ask you to rely on your own recollection of the evidence in this case.
Use your common sense in what that means. What is the person doing in its consequence? Consequence is a synonym for result. What you're doing in the result. What she was doing was shooting Robert Deans in the back of the head. What was the result? What was the consequence? He was killed. It's that simple. Did she know when she was shooting him that she was going to kill him? Well, she told Dr. Lazaro that she should be killing herself. Killing herself. She shot and killed Bob instead of killing herself. So she knew that by shooting him, she was going to kill him, the consequence. She told Dr. Lazaro that. Even Dr. Ewing came up with some weird theory that he believed the consequence she believed was that she should kill Robert Deans so that way her mother would kill her.
Objection, facts not in evidence.
I'll simply remind the jury to rely on your own recollection of what the facts in the case are, and that what the attorneys say is not evidence in the case.
Dr. Lazaro also says that she shot Bob once in the back of the head. That location is important. What does that tell you? She didn't shoot him in the back. She didn't shoot him in the leg. She didn't shoot him in the shoulder. She went right to the back of the head. Shows she knew what she was doing. She knew where she was putting that bullet. She told her brother, I shot Bob. I didn't think I could do it, but I did. What does that tell you? She knew she was doing it. She thought about it. She even says in that response, I didn't think I could do it. She was thinking about it. She knew what she was going to do. I didn't think I could do it, but I did it. So let's say consequence doesn't mean killing, but if you use the common sense thought process, didn't know what she was doing or its consequences. What are the consequences of what she did, shooting him? Well, he was going to die. But let's say it says she's going to get in trouble. How much do we know that Nicole Nachtman knew she was going to get in trouble? First thing she says, that tells the doctors, is that once she shot Bob, she was worried that the police were going to come. And she took a couple of sleeping tablets. She also flees, obviously, the minute she shoots Miriam Deans. She gets rid of the weapon. She heads up to Tallahassee. She lies to people. She lies to her uncle. She lies to the people. She knows she's in trouble. She knows the consequences. She's at average to above average intelligence. She said goodbye to the people that were most important in her life. David, Laura and Joey, she basically told them all her goodbye. She told Laura, "You've been a good friend to me." She told Joey, "I'm going to miss you, Joey." The defense would have you believe that she was suicidal, and that's why she said it. Joey asked her, "Are you thinking of this?" "Oh, no. No. And that's when she whispers, "I did it. I shot him." Ladies and gentlemen, just a few more things and I will sit down. One of the things that the judge is going to read you is an instruction that says, because your decision should not be based because you feel sorry for anyone or are angry at anyone. Ms. Nachtman, this look pretty pathetic over there.
I'm gonna object in proper argument.
Let's move on.
You've seen her. You've heard about her hard life growing up. You are not to decide this case because you feel sorry for anyone. So if you feel sorry for Nicole Nachtman because she had a rough life, but you believe she did it and she knew what she was doing, your verdict must be guilty as charged. And you do not decide the case because you're angry at anyone. Even if you're angry at Miriam Deans, even if you feel like she was a terrible mom, you don't, if you believe she did what she did and she knew what she was doing and she knew the consequences, she knew it was wrong, your verdict should be guilty as charged. Ladies and gentlemen, this is not the work of someone who did not know what they were doing or the consequence, the result of what they were doing or the wrongness. This was the work of a person with a mindset to rid their life of a burden for them. Someone who thought out and planned, granted not a mastermind, but clearly had some plan. Someone who tried to cover their tracks. Someone who killed two innocent, unarmed people by surprise. That someone, ladies and gentlemen, is Nicole Nachtman. We have no doubt, ladies and gentlemen, that upon reviewing all the evidence in this case, you will return a verdict as charged of guilty of 2 counts of murder in the first degree. Thank you.
Ladies and gentlemen of the jury, I'm now going to read you the final instructions. I want to let you know before I begin to read those final instructions that these actual instructions will go back into the jury room with you. You will have them when you are deliberating. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Nicole Nachtman, the defendant in this case, has been accused of the crimes of murder in the first degree, premeditated with a firearm. In this case, Nicole Nachtman is accused of 2 counts of murder in the first degree, premeditated with a firearm. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, all of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Robert Deans and or Miriam Deans were killed by Nicole Nachtman, you will then consider the circumstances surrounding the killings in deciding if the killings were murder in the first degree or were murder in the second degree or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following circumstances. Number 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before Nicole Nachtman may be found guilty of murder in the first degree or any lesser included crime. As to count 1, to prove the crime of first degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Robert Deans is dead. Number 2, the death was caused by the criminal act of Nicole Nachtman. 3, there was a premeditated killing of Robert Deans. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. An issue in this case is whether Nicole Nachtman did not act with a premeditated design to kill because she acted in the heat of passion based on adequate provocation. In order to find that the defendant did not act with a premeditated design to kill because she acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused death, and Nicole Nachtman was, in fact, so provoked and did not cool off before she committed the act that caused the death of Robert Deans. If you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because she acted in the heat of passion based on adequate provocation, you should not find her guilty of first-degree premeditated murder. As to count 2, to prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Miriam Deans is dead. Number 2, the death was caused by the criminal act of Nicole Nachtman. Number 3, there was a premeditated killing of Miriam Deans. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. An issue in this case is whether Nicole Nachtman did not act with premeditated design to kill because she acted in the heat of passion based on adequate provocation. In order to find that the defendant did not act with a premeditated design to kill because she acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused death, and Nicole Nachtman was, in fact, so provoked and did not cool off before she committed the act that caused the death of Miriam Deans. If you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because she acted in the heat of passion based on adequate provocation, you should not find her guilty of first-degree premeditated murder. If you find that Nicole Nachtman committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, she discharged a firearm and in doing so caused the death of Robert Deans and or Miriam Deans, you should find the defendant guilty of first-degree murder with discharge of a firearm causing death. A firearm is legally defined as any weapon, including a starter gun, which is designed to, or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder are second-degree murder and manslaughter. To prove the crime of as to count 1. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Robert Deans is dead. Number 2, the death was caused by the criminal act of Nicole Nachtman. Number 3, there was an unlawful killing of Robert Deans by an act imminently dangerous to another and demonstrating a depraved mind without regard to human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Nicole Nachtman did not have a depraved mind without regard for human life because she acted in the heat of passion on adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused death, and Nicole Nachtman was, in fact, so provoked and did not cool off before she committed the act that caused the death of Robert Deans. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, you should not find her guilty of second-degree murder. Lesser as to count 2. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Miriam Deans is dead. Number 2, the death was caused by the criminal act of Nicole Nachtman. Number 3, there was an unlawful killing of Miriam Deans by an act imminently dangerous to another and demonstrating a depraved mind without regard to human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Nicole Nachtman did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation. In order to find the defendant did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused death, and Nicole Nachtman was in fact so provoked and did not cool off before she committed the act that caused the death of Miriam Deans. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, you should not find her guilty of second-degree murder. If you find that Nicole Nachtman committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime she discharged a firearm and in doing so caused the death of Robert Deans and or Miriam Deans, you should find the defendant guilty of second-degree murder with discharge of a firearm causing death. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. Lesser as to count 1. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Robert Deans is dead. Number 2, Nicole Nachtman intentionally committed an act or acts that caused the death of Robert Deans, or the death of Robert Deans was caused by the culpable negligence of Nicole Nachtman. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care toward others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. Lesser as to count 2. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Miriam Deans is dead. Number 2, Nicole Nachtman intentionally committed an act or acts that caused the death of Miriam Deans, or the death of Miriam Deans was caused by the culpable negligence of Nicole Nachtman. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows a wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. If you find that Nicole Nachtman committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime, she personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find her guilty of manslaughter with a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to, or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, excuse me, any firearm muffler or firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. If you find that Nicole Nachtman committed manslaughter, but you are not convinced beyond a reasonable doubt that she personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find her guilty only of manslaughter. Excuse me. An issue in this case is whether Nicole Nachtman was insane when the crime allegedly was committed. A person is considered to be insane when 1. She had a mental infirmity, disease, or defect. 2. Because of this condition, A. She did not know what she was doing or its consequences, or B. Although she knew what she was doing and its consequences, she did not know it was wrong. All persons are presumed to be sane. The defendant has the burden of proving the defense of insanity by clear and convincing evidence. Clear and convincing evidence is evidence that is precise, explicit, lacking in confusion, and of such weight that it produces a firm belief without hesitation about the matter in issue. In determining the issue of insanity, you may consider the testimony of expert and non-expert witnesses. The question you must answer is not whether the defendant is insane today or has ever been insane, but whether instead the defendant was insane at the time the crime allegedly was committed. A defendant who believed that what she was doing was morally right is not insane if the defendant knew that what she was doing violated societal standards or was against the law. Unrestrained passion or ungovernable temper is not insanity, even though the normal judgment of the person is overcome by passion or temper. Although insanity is a defense, mental or psychiatric conditions not constituting insanity are not defenses to any crime in this case. Unless there is clear and convincing evidence that Nicole Nachtman was insane at the time of the crimes alleged, any evidence of mental illness, an abnormal mental condition, or diminished mental capacity may not be taken into consideration to show that she lacked the specific intent or did not have the state of mind essential to proving that she committed the crimes charged or any lesser crime. If you find that Nicole Nachtman committed murder in the first degree or murder in the second degree or manslaughter, but you find by clear and convincing evidence that the defendant was insane, then you should find her not guilty by reason of insanity. If your verdict is that the defendant is not guilty by reason of insanity, that does not necessarily mean she will be released from custody. I must conduct further proceedings to determine if the defendant should be committed to a mental hospital or given other outpatient treatment or released. It is a defense to the crimes of murder in the first degree, murder in the second degree, and manslaughter concerning Miriam Deans if the actions of Nicole Nachtman constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. The use of deadly force is justifiable if Nicole Nachtman reasonably believed that the force was necessary to prevent imminent death or great bodily harm to her while resisting 1. Another's attempt to murder her, or 2. Any attempt to commit aggravated battery or aggravated assault upon her, or 3. Any attempt to commit aggravated battery or aggravated assault upon or in any dwelling house in which she was present. Aggravated battery is defined as touching or striking or causing bodily harm to another and intentionally or knowingly causing great bodily harm to another or while using a deadly weapon. Aggravated assault is defined as intentionally and unlawfully threatening either by word or act with the apparent ability to carry out the threat to do violence to another with a deadly weapon and creating a well-founded fear that such violence was about to take place. Nicole Nachtman was justified in using deadly force if she reasonably believed that such force was necessary to prevent imminent death or great bodily harm to herself or the imminent commission of aggravated battery against herself, If Nicole Nachtman was not otherwise engaged in criminal activity and was in a place she had a right to be, then she had no duty to retreat and had the right to stand her ground. In deciding whether Nicole Nachtman was justified in the use of deadly force, you must consider the circumstances by which she was surrounded at the time the force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force. Based upon appearances, Nicole Nachtman must have actually believed that the danger was real. However, the defendant had no duty to retreat if she was not otherwise engaged in criminal activity and was in a place where she had a right to be. If you find that Nicole Nachtman, who because of threats or prior difficulties with Miriam Deans had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Miriam Deans, you may consider this fact in determining whether the actions of Nicole Nachtman were those of a reasonable person. In considering the issue of self-defense, you may take into account the relative physical abilities and capabilities of Nicole Nachtman and Miriam Deans. If in your consideration of the issue of self-defense you have a reasonable doubt on the question of whether Nicole Nachtman was justified in the use of deadly force, you should find her not guilty. However, if from the evidence you are convinced beyond a reasonable doubt that Nicole Nachtman was not justified in the use of deadly force, you should find her guilty if all the elements of the charge have been proved. You have heard evidence regarding the defendant having suffered from battered child's syndrome. This evidence was introduced to show whether it was reasonable for the defendant to believe that death or serious bodily injury was imminent as it relates to the killing of her mother, Miriam Deans. If you find that the defendant, who, because of having suffered from battered child's syndrome, had reasonable grounds to believe that she was in danger of death or great bodily harm, you may consider this evidence in determining whether the actions of the defendant were reasonable when she killed her mother, Miriam Deans. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to whether when the defendant made the statement she had been threatened in order to get her to make it, and whether anyone had promised her anything in order to get her to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussions. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not, in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the indictment or guilty of such lesser included crimes as the evidence may justify, or not guilty by reason of insanity, or not guilty. If you return a verdict of guilty, it should be for the highest offense that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. I'm going to hold it up briefly. It's a couple of pages. This is the verdict form that will be going back into the jury room with you. It'll be on top of. I take it out, I place it on top of the instructions, so that's the packet that you're going to receive. I don't expect you to read it from there. I'm going to read it to you. It is titled Verdict Form. It says, "We the jury find as follows as to count one of the charge." Then in parentheses there are instructions that say check only A, B, C, D, or E as to this count. A reads, "The defendant is guilty of murder in the first degree as charged." Then under that it reads, "If you find the defendant guilty of first degree murder, you must then answer the following questions." Question 1 reads, "During the commission of the offense, did the defendant actually possess a firearm?" And then there are two choices, yes and no. The second question is, "During the commission of the offense, did the defendant personally discharge a firearm?" And then there are two choices, yes and no. The third question, "During the commission of the offense and as a result of the discharge of the firearm, was death caused to Robert Deans?" And then two choices, yes and no. After that, choice B reads, "The defendant is guilty of murder in the second degree, a lesser included offense." Under that, it reads, if you find the defendant guilty of second degree murder, you must then answer the following questions. Question 1, during the commission of the offense, did the defendant actually possess a firearm? And then there are choices, yes and no. Number 2, during the commission of the offense, did the defendant personally discharge a firearm? And then choices, yes and no. After that, question 3, during the commission of the offense and as a result of the discharge of the firearm, was death caused to Robert Deans? And then choices, yes and no. Choice C reads, "The defendant is guilty of manslaughter, a lesser included offense. If you find the defendant guilty of manslaughter, you must then answer the following questions. During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm?" And then the choice is yes or no. D reads, "The defendant is not guilty by reason of insanity." E reads, "The defendant is not guilty." Then it reads, "We the jury find as follows as to count 2 of the charge." And in parentheses it says check only A, B, C, D, or E as to this count. Choice A reads, "The defendant is guilty of murder in the first degree as charged." Under that it reads, "If you find the defendant guilty of first degree murder, you must then answer the following questions." Number 1, during the commission of the offense, did the defendant actually possess a firearm? And then choices yes or no. 2, during the commission of the offense, did the defendant personally discharge a firearm? And then the choices yes or no. Then 3, during the commission of the offense and as a result of the discharge of the firearm, was death caused to Miriam Deans? And then the choices yes and no. Then B reads, "The defendant is guilty of murder in the second degree, a lesser included offense." Under that it reads, "If you find the defendant guilty of second degree murder, you must then answer the following questions." Number 1, during the commission of the offense, did the defendant actually possess a firearm? Choices yes and no. 2, during the commission of the offense, did the defendant personally discharge a firearm? Then the choices yes and no. 3, during the commission of the offense and as a result of the discharge of the firearm, was death caused to Miriam Deans? And then the two choices, yes and no. C reads, "The defendant is guilty of manslaughter, a lesser included offense. If you find the defendant guilty of manslaughter, you must then answer the following question," which reads, "During the commission of the offense, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm?" And then choices yes and no. Then choice D reads, "The defendant is not guilty by reason of insanity." Then choice E reads, "The defendant is not guilty." Under that it says, "So say we all, this blank day of August 2019, and then 2 lines, one for the foreperson of the jury to sign, and one for the foreperson of the jury to print their name. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty by reason of insanity as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk to the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you, it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. That is all of the instructions, ladies and gentlemen. And as I said, they're going to be going back with you. Putting the verdict form that I read to you on top, and you will receive that momentarily. So you're going to be going back there now. You may have noticed that there are more than 12 of you. We always select alternate jurors. I assure my alternate jurors that your job is just as important as the job of the 12 jurors that are going to be going back in to deliberate. I'm going to ask the alternate juror to remain back while we send everyone else into the jury room. Our alternate is Deborah Cole. And at this time, we will send the rest of the jurors in to begin deliberations. All rise for the jury. You can remain seated, Ms. Coleman. The jury has exited. Everyone else may be seated this time. Ms. Coleman, first and foremost, thank you. You have been here with us for 2 weeks now. You have you have been patient with us. You have given us your full and undivided attention, and for that, we thank you. I want to let you know at this time I'm going to release you from all of my prior restrictions as far as not doing research, not discussing the case, or anything like that. You are absolutely allowed to do any of that. Watch if there's any reports related to the case. You're welcome to do that. If you'd like to remain behind, and wait while the jury deliberates, you're welcome to do that. Let me ask, Will, did we get how many lunches?
13.
We have a lunch for you. If you want to take that with you and leave, you can do that. If you want us to find you a room, a private room to eat it in, we will do that for you. We greatly appreciate you. If you want to call to find out what the verdict was, you can do that. But most importantly, again, we want to thank you for your very important civic duty, and I will release you at this time. All rise for the alternate jury. The alternate juror has exited. Everyone may be seated. First, is there any objections to the instructions as given?
Just to the requested instructions as to self-defense on proper means and the premeditation instruction the court denied.
All right, so to stuff that wasn't given, but what was written, I understand, don't want to waive any objections to anything you requested that I didn't give. And Ms. Nachtman, I have a question of you at this time, ma'am. You don't have to stand, but are you satisfied with the services of your attorneys?
Absolutely.
All right, thank you very much. Anything from either side before we go into recess?
No, Your Honor, nothing from the state.
From the defense? All right, we will be at recess until we either have a question or a verdict from the jury. Thank you all again very much.